This is the second part relating to Maternity Benefit Act 1961 and the very amendment of 2017, and exclusively in this lecture we would like to discuss all those landmark cases that we made reference in the previous lecture regarding Maternity Benefit Act. So the Indian judiciary has been pivotal in interpreting the Maternity Benefit Act to uphold constitutional principles of equality and non-discrimination as per Article 14, which ensures equality before the law and equal protection of laws within India's jurisdiction, and as while Article 15 Clause 3 empowers the state to create special provisions for women and children, and as while Article 21 safeguards the right to life and personal liberty, allowing deprivation only by lawful means, while Article 42 of the Directive Principle of State Policy requires the state to offer maternity leave and fair and decent working conditions, while Article 39 Clause E emphasizes protecting workers' health and preventing children or adults from being forced into unsuitable labor due to economic pressure, and Article 39 Clause F mandates that children are given opportunity for healthy development and protection against exploitation and neglect. So, now we would like to discuss those landmark cases, in particularly B.Shah versus Presiding Officer of the Labour Code, which was decided in 1978, and in particularly the issue was whether Sundays and other holidays during maternity leave should be excluded from benefit calculations. The Supreme Court here ruled that maternity benefits must be calculated for the full weeks, including Sundays. The court emphasized that the law aims to ensure comprehensive protection during maternity. The judgment of the apex court clarified benefit calculations, ensuring women receive full entitlements without arbitrary exclusion. And now we would like to discuss the most important landmark judgment, and that is Air India vs. Nergesh Meerza, which was decided in 1981 by the apex court, where the Supreme Court struck down a service regulation that terminated the employment of air hostesses upon their first pregnancy. The court held such a rule to be arbitrary and violative of the provisions of Article 14 of the Fundamental Rights of the Constitution of India. The judgment reinforced the idea that employment rules should not penalize women for their biological role, setting a precedent for the future cases. And another important leading case is Neera Mathur vs. Life Insurance Corporation, which was decided in 1992, where the Supreme Court condemned the Life Insurance Corporation's practice of requiring women to disclose details about their menstrual cycles and pregnancies during recruitment. Such practices were deemed intrusive and violative of the right to privacy, which is falling under Article 21 of the Fundamental Rights relating to right to life and personal liberty. This case brought attention to discriminatory practices in recruitment processes and emphasize the need for gender sensitive workplace policies. And another important relevant leading case relating to maternity benefit is Rohini Balakrishnan vs. State of Kerala, decided in 2018. So, in this important leading case, it was pronounced that a government school teacher was denied maternity leave for her third child. The Kerala High Court ruled that maternity benefits could not be denied based on the number of children, emphasizing the importance of maternal health. This judgment affirmed the Act's purpose of safeguarding maternal and child health irrespective of family size. And another important leading case relating to maternity benefit is Municipal Corporation of Delhi versus Female Workers Master Rule and others in 2000, which would like to discuss that in particularly in this important leading case that relates to the Municipal Corporation of Delhi versus the Female Workers Master Rule and others in 2000. The apex court or the Supreme Court extended the provisions of the Maternity Benefit Act to women working on a casual or temporary basis. The court held that denying maternity benefits to women merely because of the nature of their employment would be discriminatory. This judgment underscored that maternity rights are fundamental and cannot be curtailed based on employment status. The ruling was in accordance with Article 42 of the Directive Principle of State Policy of the Constitution of India, which mandates that the state provide fair and human working conditions along with maternity benefits. And now we would like to discuss another important leading case relating to maternity benefit is Hindustan Labor Employees Union versus Hindustan Labor Limited, which was decided in 1995, and in particularly that is an important leading case where we found that in regards to the very decision delivered in this important leading case relating to Hindustan Labor Limited, and in particularly this case leads to the very conclusion that derived from this is that in particularly all the employees as ruled by the Supreme Court are entitled to maternity benefit, and as such every employee of the company are entitled to maternity benefit as it is being stipulated as per the provisions of the Act. And finally, we would like to discuss another important leading case, that is Mishra Upadhyay versus State of Uttarakhand in 2024, and where in particularly it was decided that the Supreme Court pronounced that in particularly women are entitled to full maternity benefits under the Maternity Benefits Act 1961, even if their employment contract ends before or during maternity leave, provided they have met the eligibility criteria, and that is 160 days of work in the preceding 12 months. So the court emphasized that contractual terms cannot override the Act's provisions ensuring better protection for women, either in temporary or contractual employment. So now we would like to conclude the very lecture on discussing all these important leading cases and the first lecture that we discuss all the relevant provisions of Maternity Benefit Act 1961 and those amendments of 2017 as inserted into the Regional Act of Maternity Benefit Act 1961. So, in the very conclusion, that we would like to mention that the Maternity Benefit Act has evolved significantly through judicial interventions, ensuring that the rights of working mothers are not compromised. As courts have emphasized the importance of maternity benefits as an extension of fundamental rights, striking a balance between economic considerations and social justice. However, challenges remain, particularly in the informal sector, where enforcement of the Act is still weak. Moving forward, legislative and judicial efforts must focus on bridging these gaps to ensure comprehensive protection for all working women.